Good day everyone, we are the Group 2 and the topic that was assigned to us is the Chapter 6, Judicial Review of or Relief Against Administrative Actions. So my name is Rafaela Noche and the topic that was assigned to me is the concept of judicial review. In connection with action of an administrative agency, the term judicial review may embrace any form of judicial scrutiny of a matter which arises when such action is brought into question before a court. So, ang judicial scrutiny, meron siyang 3 levels. The rational basis review, the intermediate scrutiny, and the strict scrutiny. Collaboration of courts and administrative agencies. The problem of judicial review of the action of an administrative agency necessarily brings the judicial process into conflict with the administrative process and presents vital questions as to the relative roles of an administrative agencies and the court in our system of government. Both are governmental instruments for realizing public purposes. So, yung judicial process at administrative process, minsan nagkakaroon sila ng conflict kapag nagkakaroon ng judicial review. At dahil sa conflict na yon, naku-question kung ano ba talaga yung role ng court at administrative agency sa ating government. Pero parehas naman sila is instrument for realizing public purposes. Number 2, accommodation of administrative process to the judicial system. Administrative agency have their source of necessity to perform function which are beyond the capacity of the court, and the role of the courts in regard to administrative action is the accommodation of the administrative process to the traditional judicial system and to reconcile democratic safeguards and standards, fair play with the effective conduct of government. Yung administrative agencies, meron silang sariling source of necessity at kaya nilang mag-exist kahit na hindi sila tulungan ng iba. Tapos kaya din nilang i-perform yung mga functions nila kasi nga yung power ng court is sa loob lang ng court umiikot. Kaya ang role lang ng court is to accommodate the administrative process. Policy of the courts. It is the policy of the courts not to interfere with the actions of government agencies entrusted with the regulation of activities coming under their special knowledge and training of specific field of expertise unless there is a clear showing of capricious or whimsical exercise of judgment or grave abuse of discretion amounting to lack the or excess of jurisdiction, considering that by their nature and functions, they are in the best position to know the limits of the power under prevailing circumstances or situations. So, isa sa policy ng court ang wag makialam sa mga decisions or actions na ginagawa ng mga government agencies kasi alam nila kung ano yung ginagawa nila. Mangingialam lang yung court kung sakaling nakakita sila ng grave abuse of discretion sa mga desisyon na ginawa ng mga government agency. Right to judicial review has reference both to the power and right of court to grant the review sought in the person who invokes the power of the court. When right granted by statute, the legislative practice has ordinarily been to provide judicial review for administrative adjudications whether requires by constitutional commands or not. So dito, yung mga tao na nangangailangan ng power ng court ay may karapatan na mag-request o magkaroon ng judicial review tungkol doon sa kaso na kinsasangkutan nila. Where judicial review is provided in the statute, the right of appeal to the court is to be determined by looking at the statute, the valid regulations promulgated pursuant to it, and proven administrative practice, throwing light upon their meaning. So, the right to appeal to the court, Madedetermine lang yon sa pamamagitan ng pagtingin sa statute or yung written law. Letter B, as a rule, where legislation provides for an appeal from decisions of certain administrative bodies to the Court of Appeals, it means that such bodies are co-equal with the regional trial court in terms of role and statute and logically beyond the control of the latter. So, sinasabi bilang rule, yung administrative bodies at saka yung mga regional trial court is iisa lang sila in terms of their roles at saka statute. Number 2, when review not provided by statute, there is no inherent right to judicial review of the action of an administrative agency. So, sinasabi na yung right to judicial review daw is hindi siya inherent or permanent. Walang existing na right to judicial review. Kasi magkakaroon lang yun kapag halimbawang nag-ano ka ng kaso sa court. Letter A, appeal is of a statutory origin. It is not a requirement of due process. The fact, however, that the statute does not provide for judicial relief or review does not mean that there is no power or right of relief or review in the proper case under the general power and jurisdiction of court. So, hindi daw ibig sabihin na dahil wala sa statute or hindi nakasulat dun sa written law na pwedeng mag-provide ng judicial review is hindi na sila magkakaroon ng judicial review. So, syempre, karapatan din yun ng mga tao na mayroong final na kaso na humihiling ng review. Kaya, kahit na hindi siya nakasulat dun sa statute, right pa din nila yon na magkaroon ng judicial review. Letter B, in many situations, the Constitution is held to require judicial review even though a statute does not and even though the statute attempts to preclude judicial review. So, ito yung sinasabi ko kanina na hindi ibig sabihin na wala sa statute yung pagkakaroon ng judicial review. Yung Constitution is require pa din yung pagkakaroon ng judicial review. Number 3, where review precluded or restricted by statute, very rarely do statutes withhold judicial review. The courts are exceedingly slow to rule that a statute precludes all judicial review and have gone far toward establishing the proposition that preclusion of judicial review of administrative actions adjudicating rights is not lightly to be inferred. So, konti lang yung mga statutes na hindi pabor o ayaw ng judicial review. Letter A, it appears to be the general rule that where a full hearing is provided before a proper tribunal, the determination of the tribunal may be made final, or if an appeal is allowed, the matter to be inquired into an appeal may, in the discretion of legislature, be limited. So, yung pag-a-appeal is limited lang siya kasi saad din siya doon sa rule na dapat yung decision is final na or yung determination kapag nangyayari na yung hearing. Letter B, Congress is constitutionally free to make an administrative determination final and immune from judicial review where it gives the aggrieved party a right to elect in the first place between administrative or judicial relief. So, yung Congress may kapangyarihan sila na gumawa ng administrative determination na final na. Tapos, hindi na siya pwedeng ulit sa judicial review. Letter C, administrative determination involving political question need to be submitted to a court for review and do not ordinarily fall within the scope of judicial power. So, yung mga administrative determination na mayroong political questions, kailangan pa rin siyang ipasa doon sa court. D. The government is not by the creation of claims against itself bound to provide a remedy in the courts. It may withhold all remedies or it may provide an administrative remedy and make it exclusive, however mistaken its exercise is. So, yung desisyon na gagawin ng court at saka ng mga administrative body, walang pananagutan yung government at kung sakali man na nagkaroon ng error, hindi sila sagot ng government kasi yun nga yung trabaho nila. So, dapat kung ano yung desisyon nila, papangatawanan nila. E. When Congress grants a right to resort the court by way of appeal, it may restrict review to a single court and it need not provided for the appeal to the Supreme Court. So, kapag yung Congress nagbigay na siya ng karapatan to resort the counts by the way of appeal, hindi na siya pwedeng ma-review sa single court at hindi na rin pwedeng mag-provide ng appeal sa Supreme Court. F. Congress may place procedural conditions and restrictions upon the right to judicial review. So, yung Congress, gagawa sila ng mga conditions regarding doon sa right to judicial review. Ganun na din yung mga restrictions kapag ka ng judicial review. Letter G. Provisions that administrative decisions or actions shall be subject only to administrative review or shall be final or conclusive have also been held to preclude judicial review where no constitutional right was involved. And in regard to a decision in the exercise of purely administrative or legislative power where the statute also provide exclusive jurisdiction in the agency. H. Similarly, there can be no constitutional objection to making findings of fact conclusive if supported by evidence or to a provision that rules, regulations, or orders shall not be set aside unless it appeared that the finding were against the weight of evidence. So, hindi pwedeng magkaroon ng objection or constitutional objection kung yung fact is conclusive at saka supported ng mabigat na ebidensya. 4. Where review a matter of constitutional necessity. Judicial review of administrative action becomes a matter of constitutional necessity in some situations. A court will provide relief or review though no statute attempts to preclude review. A. Apart from express constitutional provisions providing for judicial review of judicial or quasi-judicial acts of administrative agencies which affect private rights, the right and power of and necessity for judicial review springs from the fundamental concept of the supremacy of law, which lodge in the court inherent authority to determine the constitutionality of statutes and therefore the constitutionality of the exercise of legislative power delegated by Congress to administrative agencies and from the principle of separation of powers. B. Congress is without authority to nullify rights conferred by the Constitution or to divert the courts of the power vested in them by the Constitution. Judicial power under the Constitution includes not only the duty of the courts to settle actual controversies but also the duty to determine whether or not there was a grave abuse of discretion amounting to lack excess of jurisdiction on the part of any branch or instrumentality of the government. So, yung Congress, wala silang kapangyarihan para tanggalin yung power ng court na vested sa kanila by the Constitution. Number 5. Where administrative decisions has become final and executory. The rule of res judicata, which forbids the reopening of a matter once judicially determined by competent authority, applies as well to the judicial and quasi-judicial acts of administrative officers and board acting within their jurisdiction as to the judgment of power having general judicial power. So, yung res judicata, isa siyang rule na nagsasabi na hindi na pwedeng buksan muli yung matter na determined na by the authority. So, this is res judicata when the following requisites are present. Letter A, final judgment or order. B, jurisdiction of the court or agency over the subject matter and the parties. And C, identify of parties, identify of subject matter, and identify cause of action. Number 6, where administrative decisions declared final and unappealable by statute. They are still subject to judicial review if they fail to the test of arbitrariness. Even decisions of certain administrative agencies which are declared final by law are not exempt from judicial review when so warranted as were want of jurisdiction, want of substantial basis, in fact, or in law, grave abuse of discretion, violation of due process, denial of substantial justice, fraud, or erroneous interpretation of the law is brought to the attention of the court. Factual findings of administrative agencies are not infallible and will be set aside when they fail the test of arbitrariness or upon proof of gross abuse discretion, fraud, or error of law.
Hi everyone, let's talk about rules governing appeals from judgments of quasi-judicial agencies. But before that, let's define quasi-judicial agencies. These agencies are the Civil Service Commission, Central Board of Assessments Appeals, Securities and Exchange Commission, Land Registration Authority, Social Security Commission, Office of the President, Civil Aeronautic Board, National Telecommunication Commission, Agricultural Invention Board, Insurance Commission, Philippine Atomic Energy Commission, Board of Investments and Construction Industry Arbitration Commissions. These agencies or body has been defined as an organ of government other than a court and other than a legislature which affects the right of private parties through their adjudication on rulemaking. The very definition of an administration agency includes its being vested with quasi-judicial powers. That's why it's important for us to study the rules governing appeals from judgments of quasi-judicial agencies. These are the following rules. Number 1. Where to appeal. An appeal is the process in which cases are reviewed by a higher authority where parties request a formal change to an official decision. Appeals functions. Number 2. Period of appeal. An appeal must be taken within 15 days from promulgation of the judgment or from notice of the final order appealed from. Number 3. How to appeal. After the lower court judgment is entered into the record, the losing party must file a notice of appeal, request transcripts or other records of the trial court, file briefs with the appeals court citing legal reason for overturning the ruling. Number 4. Contents of the petition. An election petition shall contain a concise statement of the material facts on which the petitioner relies. Any schedule or announcement to the petition shall also be signed by the petitioner and verified in the same manner as the petition. Number 5. Effect of failure to comply with requirements. Any organization which fails to comply with legislation runs the risk of a loss of reputation and with it the loss of customers. The damage caused to an organization reputation by a criminal conviction could last longer than the initial financial outlay. Number 6. Action on the petition. A petition is a request to do something, typically to a government agency or public official. The request is made on behalf of a group, with individuals of the group recording their assent in some way, such as signing their name to the request. Number 7. Contents of comment. A statement made by a judge or an attorney during a trial which is based on an alleged fact but not a proven fact, properly if made in the presence of the jury, the jurors should be reminded it is not evidence and it should not be considered, but how can a juror forget? Number 8. Due course. This phrase is synonymous with due process of law or the law of the land, and the general definition thereof is law in its regular course of administration through court of justice. Number 9. Transmitted of record. Transmission of the records is effected when the clerk of the trial court mails on otherwise forwards the record to the clerk of the appellate court. The clerk of the trial court shall indicate by endorsement on the face of the record or otherwise the date upon which it is transmitted to the appellate court. Number 10. Effect of appeal. An appeal taken by one or more of several accused shall not affect those who did not appeal, except insofar as the judgment of the appellate court is favorable and applicable to the latter. Number 11. Submission for decision. The review process for submissions to decision analysis is similar to that used by other scholarly journals published by Informs. When a manuscript is submitted, the editor-in-chief determines whether the topics is suitable for the journal.
Evening everybody. For today's topic, I'm going to discuss about the administrative findings and construction generally conclusive. And for today's topic, before we're going to proceed to the next steps, I'm just going to tackle all those activities which in relation to this administrative findings. So what is administrative findings? Well, basically this is about cases. This is about an activity that is usually happened. Basically, ito yung mga ahensya. I mean, ito yung mga actual activities na nangyayari, particularly doon sa mga agencies ng government natin. And yeah, with that being said, we have a lot of government agencies here in our country, and each of them have different function. Sa madaling salita, lahat sila ay may kanya-kanyang tungkulin upang matugunan yung iba't ibang industriya na nandito sa ating bansa. Hindi lang industriya, kundi yung mga taong nakapaloob dito sa ahensya na to at sa industriyang ito. We are now going to proceed to the first bullet in this administrative findings and constructions generally conclusive. And the first bullet in here is, in reviewing administrative decisions, the reviewing court cannot be re-examined or weigh once more factual basis and sufficiency of the evidence submitted before the administrative body and substitute its own judgment for that of said body to receive additional evidence that was not submitted to the administrative agency concerned. So with that being said, in this particular topic, I will give you some keywords that is in relation with this topic, each bullet being submitted from this administrative agency concerned. Alright, the second bullet we're going to discuss is bullet 1A. Litany of cases has consistently held that substantial evidence is all that is needed to support an administrative finding of fact. So with that being said, held that substantial evidence is all that is needed to support an administrative finding of fact. So which means, right, for example, in an administrative case, to a president that he is being charged for corruption. With that being said, what are those substantial evidence that we have to gathered? For example, we have the SAL-end, we have the statement of account. Those are substantial evidence that being needed to find a fact of this case. Alright? Alright, for the next bullet, we have here, by reason of their special knowledge, expertise, and experience gained from the handling of specific matters falling under the respective jurisdictions and which are addressed to their sound discretion, the court ordinarily accord great weight and respect, if not finality, to factual findings of administrative tribunals. Yes, on this particular topic, this is really important. In the last part of this, it says the courts ordinarily accord great weight and respect, if not finality, to factual findings of administrative tribunal. So which means this is in relation to the first paragraph of this topic, because their knowledge, their expertise, our experience that is being gained in handling of specific matters falling under their respective jurisdictions. This is really important because their experience can be able to determine this case, if how is it going through, how are they going to make a decision in the particular case without, and those reasons I have mentioned earlier, those are important in making a decision, not in finality to factual findings of administrative tribunal. Yes, in 1987 Philippine Constitution, we have the check and balances, and this means the separation of powers when it comes to different government agencies that we have in our country. And the reviewing court should have to respect sometime when it comes to the decision of the administrative agencies to this administrative agencies concerned.
Good day everyone, I am Mariano from ABPS City, and I'll be discussing about the finality of administrative action for purposes of review. Okay, number 1, fallacy of courts. Courts are reluctant to interfere with action of an administrative agency prior to its completion or finality, the reason being that absent a final order or decision, power has not been fully and finally exercised, and there can usually be no irreparable harm. It is only after judicial review is no longer premature that a court may ascertain in proper cases whether the administrative action or findings are not in violation of law or are free from fraud or imposition or find substantial support from the evidence. Means, the federal court's most important power is that of judicial review, the authority to interpret the Constitution. When federal judges rule that laws or government actions violate the spirit of the Constitution, they profoundly shape public policy. Next, number 2, order or decision. Statutes relating to judicial review of action of an administrative agency commonly provide for review any order, final orders, final agency action, or final decisions. Letter A. A particular order or determination may be held not subject to review because it does not constitute an order or decision, or because it does not meet other requirements specifically laid down in the statutes providing for review. Thus, review may be denied as to mere pronouncement or recommendation not acted upon. Next. The mere informality of a decision does not prevent its review if it is otherwise final. Thus, a letter may constitute an appealable order or determination. Findings may constitute a reviewable order where further proceedings have been ordered discontinued. Yung order or decision may accompany an opinion or opinions. But if it does not, it tends to be brief and not to be of reasons. It may deal with one or more cases and may dispose of those cases or not. A decision is a loose term or the set of opinions that accompany an order combined with that order. Example, in a case the petitioner appealed to the Supreme Court from the decision of only one of the commissioners in the Workmen's Compensation Commission, the appeal was dismissed as premature since the petitioner filed the petition for review without first seeking remedy from Commission and Bank as required by its rules and regulation, just like what I'd said in number 2. Okay, number 3. Judicial relief or review is lack of finality where action of the administrative agency is only anticipated, even though threatened, or where action is still pending without final disposition. Letter A. Jurisdiction lies in the administrative agency rather than in the courts. Ibig sabihin, yung jurisdiction is mas nakasalalay siya sa ahensya ng administrative kaysa sa mga korte. Letter B. An administrative officer to whom public duties are confined by law is not subject to the control of the courts in the exercise of the judgment and discretion, with the law reposes in him as part of his official function. Ibig sabihin, yung mga administrative officer na pinagtutuunan ng batas na matungkol sa public ay hindi napapailalim sa kontrol ng mga korte. Dahil yung mga decision about sa batas ay tumutukoy sa bilang bahagi ng kanyang mga opisyal na tungkulin. Next. Letter C. Determinations by subordinate official acting under the instruction of their official superior, are in the nature of things under the control of and subject to review by their official superiors. Yung mga decision ng mga nasakupang opisyal, kumikilo siya under sa tagubilin ng kanilang mga opisyal na nakatataas yung yung official superior. Sila yung mga nag-review nun. Next, letter D. The courts will not render a decree in advance of the agency's actions and thereby render such action nugatory. Ibig sabihin, yung korte ay hindi nagbibigay ng isang kautusan ng maaga sa aksyon ng ahensya at sa nugatory ang natunang pagkilo. So, ang sabi, nanggagaling daw yun sa nugatory. Nugatory, tama. Letter E. It is not for a court to stop an administrative officer from performing his statutory duty for fear he will perform it wrongly, particularly where the statute is not unconstitutional on its face, that to interfere with action which is simply threatened would render statute would unduly hamper the this agency of the responsibility, or prior to final administrative determination the party seeking relief has not suffered as present injury. So, hindi para sa isang korte na hihinto ang isang opisyal ng administratibo mula sa pagsasagawa ng kanyang tungkulin. Ayon sa batas daw, dahil sa takot na magampanan niya ito ng mali. Lalo na kung ang batas ay hindi salungat sa konstitusyon, sa mukha nito na makagambala sa aksyon na kung saan ay banta lamang. Next, action requiring approval by superior. An order required to be submitted to a superior for approval is not final for purposes of review. However, the fact that in some circumstances the grant of relief might have to submitted for approval does not detract from the finality of an order denying relief. Next, sabi doon, yung kilos nangangailangan ng pag-aproba ng superior, yung mga mas nakakataas. Ang isang order na kinakailangan upang isubmit sa isang nakahihigit para sa pag-aproba ay hindi pangwakas para sa mga layunin ng pagsusuri. Gayunpaman, ang katotohanan na sa ilang mga pangyayari, ang pagbibigay ng kaluwagan ay maaaring isubmit para sa pag-aproba ay hindi makakalis sa wakas ng isang utos na tumanggi sa kaluwagan. Next, pendency of rehearing or administrative appeal. The pendency of an application for a rehearing or recommendation filed within the time prescribed by law or regulations deprives the original order of finality. However, a statute may provide otherwise. Rules and regulations. Regulation of an administrative agency are addressed to and set a standard of conduct for all to whom their terms apply. Kadahilanan ng isang aplikasyon para sa isang pag-eensayo o recommendation ng isinampa sa loob ng oras na inireseta ng batas o mga regulasyon ay nagtatanggal sa orihinal na pagkakasunod-sunod ng panghuli. Gayunpaman, ang isang batas ay maaari magbigay ng iba. Next, yung mga rules and regulations. Ang mga regulasyon ng isang ahensya na pang-administratibo ay nakatuon at nagtatakda ng isang pamantayan ng pag-uugali para sa lahat kung kanino nalalapat ang kanilang mga tuntunin. So, kailangan nakatuon at nakatakda doon sa pamantayan ng isang administrative agency. Next, where administrative regulations affect or determine rights generally and non-compliance is penalized, they are appropriately the subject of attack under statutes authorizing a suit to enjoin, set aside, annul, or suspend any order even though not directed to any particular person or corporation. Kung saan ang mga regulasyon pang administratibo ay naka-apekto o tumutukoy siya sa karapatan ng pangkahalatan. At ang hindi pagsunod sa pinarusahan na angkop na paksa ng pag-atake sa ilalim ng isang batas, nagpapahintulot sa isang set na mag-utos magtabi, pawalan o spindihin ang anumang utos kahit na hindi nakadirekta sa anumang partikular na tao o korporasyon. Letter B. But rules and regulation, even though arbitrary or discriminatory with respect to particular individuals, are not subject to challenge in a judicial proceeding prior to the time when administrative action pursuant to such rules and regulations constitutes a present invasion of private rights. No such invasion exists where such rules and regulations are advisory only and not enforceable. Sabihin, yung mga patakaran at regulasyon kahit na arbitrary siya or discriminatory patungkol sa mga particular na individual ay hindi napapailalim sa hamon sa isang paglilitis sa paghukuman bago ang oras kung kailan ang aksyon administratibo alinsulod sa naturang mga patakaran at regulasyon ay bumubuo ng isang kasalukuyang pagsalakay sa mga pribadong karapatan. Walang gaanong pagsalakay na mayroon kung saan ang mga naturang panuntunan at regulasyon ay payo lamang at hindi maipapatupad. Next, number 7. Purely administrative matters, it is a well-recognized principle that purely administrative and discretionary functions may not be interfered with by the courts. In general, courts have no supervising power over the proceedings and actions of administrative departments of the government. A. Thus, the matter of awarding market stalls in the city of Manila was held entirely administrative, coming within of the city mayor, and his action is final unless otherwise decreed by competent legal authority or power to be an abuse of authority. B. The power granted to the Secretary of Agriculture and Commerce, no environment and natural resources by law regarding the disposition of public lands, such as granting of licenses, permits, leases, and contracts, or approving, rejecting, reinstating, canceling applications, or deciding conflicting applications were held to be executive and administrative in nature. Ang mga kapangyarihan ay pinagkaloob sa kalihim ng agrikultura at komersyo, ngayon ang kapaligiran at likas na yaman ng batas hinggil sa pagtatapon ng mga pampublikong lupain tulad ng pagbibigay ng mga lisensya, mga permiso, mga pag-upa at mga kontrata, pati yung pag-aproba, pagtanggi sa pagbabalik sa pagkansela ng mga aplikasyon or pagpapasya ng mga magkasalungat ng mga aplikasyon ay pinangasiwaan ng mga likas na ehekutibo at pang-administratibo. So yun nga, yung ibig sabihin nun, yung executive and administrative in nature. Sila yung nagde-decide about the conflict sa mga applications. Next, letter C. For reasons of practicability and expediency, Courts have no jurisdiction to review the purely administrative practice of immigration authority of granting formal hearings in penons, extensions of stay, affiliates under CA number 613, otherwise as the Immigration Act of 1940. Sa mga kadahilanan ng practical o kakahiyang magamit, walang jurisdiction ang mga korte upang suriin ang puls mga administratibong kasanayan ng otoridad sa imigrasyon or kontrata pag-apurba upang surian ang pulos mga administratibong kasanayan ng otoridad sa imigrasyon o pagbibigay ng formal na pagdinig sa mga extension ng pensions o manatili sa mga dayuhan sa ilalim ng nasabing batas. Next, preliminary, procedural, and interlocutory determination. The universal rule is that appeal to the courts will not lie from an interlocutory order unless such order affects the merits. Sabihin, paunang pamamaraan at interlocutory na pagpapasya ang panlahatang panuntunan ng apela ng korte ay hindi magsisinungaling mula sa isang kausap pa, maliban kung ang naturang kautusan ay nakakaapekto sa mga merits. Okay. Next tayo. Ito yung mga examples of orders failing under this kind of determination. Una, orders directing an investigation and inquiry, appointing and conservator or conciliator, providing for a hearing and requiring corporations under investigation to appear and present certain data. Next, denial of a motion to change place of hearing. Next, denial of application for stay. Next, approval or disapproval of a compromise agreement. Next, application for hearing. And last, an order of an administrative affiliate tribunal reversing and remanding a case to the hearing officer to take further testimony, but certiorari is available against administrative agency exercising quasi-judicial functions, whether the order is interlocutory or not, where due process was not followed. Next, ito yung case about ito yung case about GR number L 39741 noong 1975, Nation Multi-Service Labor Union versus Mariano B. Agaucili. Okay, judge entertained a suit for prohibition involving a decision of the Secretary of Labor in a labor case, which decision had already attained the status of finally. Facts. The present controversy originated from 3 unfair labor practice cases filed with the National Labor Relations Commission or NLRC. Created under Presidential Decree Number 21, the compulsory arbitrator in his decision declared respondent a hotel guilty of unfair labor practice. The matter in controversy was passed upon the NLRC and lastly by the Secretary of Labor. Issue: did the respondent judge commit a grave abuse of discretion in issuing the restraining order? So, decision or held, yes. Appeal to the President provided in the law. The appropriate step to take if private respondent were dissatisfied was to appeal to the President, so it was provided in such decree. They did not do so, it would have been executed then, were it not for the actions instituted in the sala of respondent judge, who is on record as entertaining such suit on because of the vehemence with which the private respondents raised the procedural due process objection. So, sabi, it is made clear that this decision deals specifically with a proceeding before the defunct National Labor Relations Commission. Nothing in the opinion should be construed as having reference to the procedure to be followed and the role of the courts. For judicial intervention is sought in controversial facts upon the present National Labor Relations Commission created under the new Labor Code. Next. Number 2 is about a private respondent had full opportunity to cure any due process deficiency. A more careful scrutiny, however, would have yielded a different conclusion. The factual basis for binding determination was laid before the compulsory arbitrary. He sustained petitioners except that he did not agree that there was an employer-employee relationship between the individual petitioners and private respondents. Next case. Case is all about Philippine Airlines versus Civil Aeronautics, Port and Grand International Airways. So the petitioner in this case is Philippine Airlines, and the respondent is the Civil Aeronautics. So facts, this is a petition for certiorari by the Philippine Airlines or PAL to set aside and declare void a resolution of the Civil Aeronautics Board approving the application of JL, operator of an airline, for a provisional permit to operate 4 aircraft effective from receipt of said resolution up to the time a decision is rendered by CAB on his application. FAL would have the court declared void such grant of provisional authority alleging denial of due process, assigning as alleged errors of CAB its failure to hear its evidence which it could be offered, the absence of any factual basis for the grant of authority, the findings of the here examiner being in fact opposed to the same, the absence of the reasons for said grant, and the absence of any finding. The issue, number 1, certiorari available as a remedy against administrative agencies like CAB. Number 2, did CAB exceed its jurisdiction or at the very least act with great abuse of discretion in granting the provisional authority to operate? Held. Certiorari available as remedy against administrative agency. This is not petition for review under the Civil Aeronautics Act of the Philippines. The procedure for the processing of the application of certificate of public convenience and necessity had been established to ensure the weeding out of those entities that are not deserving of public officer. In sum, respondent board should not be allowed to continue hearing the application and grant for the issuance of a certificate of public convenience and necessity, there being no legal obstacle to the exercise of jurisdiction. Therefore, the court resolved to dismiss the instant petition for lack of merit. The respondent Civil Aeronautics Board is hereby directed to continue hearing the application of respondent Grant International Airways for the issuance of a certificate of public convenience and necessity. So that's all. Thank you for listening to my report.
Good day everyone, my name is Mirlito A, Agabon, and I'm here to discuss the exceptions to the doctrine of finality. Number 1. Review at an initial or intermediate stage of administrative actions. The requirement of finality is subject to exceptions and limitations which permit judicial relief for an review at an initial or intermediate stage of the administrative actions. Thus, the fact that a particular determination is not a final order for purposes of statutory review has been held not to preclude the availability of judicial review. Letter A. To an interlocutory order affecting the merits of the controversies. Letter B. To grant relief to preserve the status quo pending further actions by the administrative agencies. C. When it is essential to the protection of the rights asserted from the injury threatened. D. Where an administrative officer is assumed to act in violation of the Constitution and other laws. E. Where such order is not reviewable in any other way and the complaint will suffer great and obvious damage if the order is carried out. And F. To an order made in excess of power, contrary to a specific prohibition in a statute governing the agencies and thus operating is a deprivation of right assured by the statute. Number 2. Reviewed allowed by the statutory provisions. In some instances, exceptions to the requirement of finality or limitations on such requirement flow directly from statutory provisions. Thus, it has been said that it is settled rule that the declaratory judgment law is applicable and appropriate in instances where there is no final decision or rule of an administrative agencies which could be reviewed by an existence remedies such as appeal. Timing of application to courts. Divisions of functions between courts and administrative agencies inevitably creates problems of determining which tribunal may take initial actions and at what stage of administrative actions our aggrieved party may go to the court. These problems are governed by three main doctrines. Number 1, the doctrine of primary jurisdiction is not concerned with judicial review but determines in some circumstances whether initial action should be taken by a court or by an administrative agencies. Number 2, the doctrine of exhaustion of administrative remedies is designed primarily to control the timing of judicial relief from adjudicative actions of an agencies. It is customarily applied to adjudication and not to rulemaking. And last, the doctrine of rightness for review is in essence the same as that of exhaustion of administrative remedies, except that it is applied to rulemaking and to administrative action, which is embodied neither in rules or regulations nor in adjudication or final orders.
Primary jurisdiction. Doctrine is a judicial doctrine whereby a court stands to a favor, allowing an agency an initial opportunity to decide an issue in a case in which the court and the agency have concurrent jurisdiction. It is the principle that the courts cannot or will not determine a controversy involving a question which is within the jurisdiction of an administrative tribunal prior to the decision of the question by the administrative tribunal, where the case demands the exercise of administrative discretion requiring special knowledge, experience, and services of the administrative tribunal to determine a technical and intricate matters of facts. wherein uniformity of ruling is essential to comply with the purposes of the regulatory statute administered. Application of doctrine. There are 4 possible cases in which the rule of last clear chance can be applied. The typical last clear chance situation involves the helpless plaintiff against the observant defendant, and all the courts that accept the doctrine will apply it. The few courts that do not recognize the rule attain the same result under the doctrine of willful and wanton misconduct. In the helpless plaintiff, inattentive defendant, and the inattentive plaintiff observant defendant cases, most jurisdictions that acknowledge the rule apply it, where the case entails the inattentive plaintiff against the inattentive defendant. The justification for the rule are eliminated, and nearly all jurisdictions refuse to apply it. The defendant's negligence must occur subsequent to that point in time when the person discovered or should have discovered plaintiff peril.
Hello class, I'm going to report is about a doctrine of exhaustion of administrative remedies. What is definition of doctrine of exhaustion of administrative remedies? The doctrine of exhaustion of remedies says that a person challenging an agency decision must first pursue the agency available remedies before seeking judicial review. It was created by courts in order to promote an efficient justice system and autonomous administrative state. Congress has seen written exhaustion requirements into May statutes to ensure and guide its application. The doctrine of exhaustion of administrative remedies is held whenever there is available administrative remedy that should be used up or exhausted before a recourse to judicial action. This is in order to provide an orderly produce prescribed by law with respect to matters peculiarly within the competence of the administrative agency. Give the agency an opportunity to decide on its own matters and to correct its own errors. Prevent unnecessary and premature resort to the court. Yan po yung para sa akin ng ibig sabihin po nung the doctrine of exhaustion of administrative remedies. Next is what is legal and practical reason for doctrine. Courts have justified criminal respondent superior in the grant that it increase incentives for corporation to monitor and privilege and prevent illegal employee conduct. This reasoning assumes that imposing broad liability and dire sanction on corporation for their agents actions will prompt them to take steps to prevent this misconduct. That's it na. Hopefully, kahit hindi ko po masyadong explain ng masyado, isensya na po, and thank you po guys. Have a nice day and ingat po tayo palagi. Thank you po.
My name is Elizabeth Espi from ABPS 33 Group 2. My topic report is about application of the doctrine and the instances where doctrine has been applied. Application of the doctrine as a prerequisite of judicial review. In some instances, the statute makes the exhaustion of the remedies a precondition of the right to seek the intervention of the courts. The classic example ng failure to exhaust administrative remedies ay yung nakapag-appeal mula sa administrative decision to a higher administrative authority or tribunal within administrative system. Pag sinabing judicial review, ito yung proceedings in which a court is asked to rule on a decision of an administrative body or quasi-judicial tribunal. Application of the doctrine as affecting one's cause of action. The authorities are not in accord as to whether the application of the doctrine lies the discretion of the court or goes to its jurisdiction and does not permit the exercise of discretion. Some cases have held that the requirement may be waived by the parties and the proceedings entertained by the court, and that the court in some situation may in its own discretion relax the rule. Yung ibang cases na naganap kung saan yung batas natin ay na-apply dahil yung court natin ay kulang sa jurisdiction to act. Kunwari sa isang kaso, walang tumugmang batas na ipapataw sa kanila. So, dito papasok yung application of doctrine. Gagawa sila ng panibagong batas. Siyempre, may process doon. May process din yon at hindi agad-agad. Next topic ay instances where doctrine has been applied. So, certiorari cannot be sustained where the administrative remedies were not exhausted, thus were under the rule of procedure of an administrative agency, the aggrieved parties is allowed to file a motion for reconsideration of any order, resolution, or decision thereof. Such motion must be filed before the special civil action for certiorari may be availed of. So, meron tayong administrative agency or body kung saan ang batas ay umiiral ng tama. This is called due process. Pwede makapag-file ng motion of reconsideration ang isang party or respondent or complainant bago pa magkaroon ng civil action sa isang kaso for certiorari. Therefore, hindi ma-actionan or ma-sustain yung certiorari kung ito ay ditugma at may kulang ang pagkalap ng datos ng isang salaysay. Kumbaga, di siya ma-resolutionan because of having failed to get remedy. Walang certiorari magaganap sa isang administrative agency. Remedy from the court cannot be sought. Petitioner never filed a motion for reconsideration of the decision of the Civil Service Commissioner and no appeal was made to the Civil Service Board of Appeals. If the petitioner galing na siya sa court without remedy from filing the motion ng kanyang gusto or ninanais, never siya mag-file ng motion of reconsideration sa civil service. Commissioner kasi, only administrative agency lang allowed. Since may kanya-kanyang access ang Civil Service Board Appeals. The delay in the immigration commissionaries action does not constitute an exception to the rule, for it is precisely such delay, among other undesirable and unjustified shortcomings, that should be brought to the attention of the Secretary of Justice for remedial action. In every rule, may mga shortcomings undesirable and unjustified. Like yung pag-delay about sa immigration commissionaries action. So sabi pag walang exception, yun sa rule, kung meron man dapat dalhin agad sa Secretary of Justice for remedial action para mapabilis ang pag-process ng isang kaso at hindi ma-delayed. So, filing a complaint in court without waiting for the decision of the Auditor General, Commissioner on Audit na ngayon, from which if adverse or not satisfied therewith, the petitioner could have appealed to the President before or to the Supreme Court, does not exhaust administrative remedies. So, bago man mag-file ng complaint ng isang complainant in court, dapat pumunta muna siya sa president or president nila ng organization nila or in the Supreme Court para mapabilis ang process at hindi niya na kailangan hintayin pa yung Auditor General para sa complaint. Means yung pag-complaint niya is without attempt in having fake or unreliable source para ang litigation ng kaso tuloy-tuloy. So it is the duty of a party aggrieved by an administrative adjudication for ascertain what good will be done by higher authorities. Considering that the President of the University of the Philippines is subject to the direction of the Board of Regents and that the Board has the power to annul or modify an order or circular issued by the President, it is the legal obligation of the petitioners to appeal to the Board before resorting to the court. So, bago magsampa ng kaso, ang petitioner ng university, pwedeng idaan muna sa president ng nasabing university. Kasi, may kapangyarihan siya na ayusin ang isang kaso basta nasa sinasakupan niya. So, ito yung last. The claim of denial of due process to show that their case falls within one of the exception to the doctrine is untenable, for it appears that the petitioner were made to avail in the same administrative agency the opportunity or right to oppose, which in fact they did when they filed a motion for reconsideration and later when the motion was denied. They appealed to the department secretary. Precisely, a motion for reconsideration or appeal is curative in character on this issue of alleged denial of due process. So whether or not a motion for reconsideration of an administrative decision is essential in exhausting available administrative remedies before a party can turn to the courts for relief would largely depend upon the pertinent laws, rules of procedure, and the usual practice followed in the particular office.
Hi, I'm Allan A. Sanchez, ABPS 3-3. I'll be reporting exception to the doctrine. But first, I will discuss the exhaustion of the doctrine of exhaustion of the administrative remedies. The person must avail first all the means for the process of the administrative remedies. If all the administrative remedies has been exhausted, only then that the person could seek the court intervention. Exception to the doctrine when the issue involved clearly the question of law. Also when there's when the due process is violated, when it's also when it's a question of the private land and it should be in the land case proceeding. Also when there is unreasonable delay. Also when there's clearly no remedy at all, or no remedy that the courts is needed. Well, I mean, no decision can be made. Only that the court can intervene. And also in the where the result of administrative remedy will sort to bias. Baba. When also when exception to the doctrine, also when there will be more damage to both parties. Court intervention is needed. I hope that you understand. Thank you.
Exhaustion of doctrine and primary jurisdiction doctrine distinguish illustrative case. Both doctrine are concerned with the promoting proper relationship between the court and administrative agency, permitting the court to obtain, accept as in the solution of technically problem, and then the net result of the application of other rules is practically the same. The two doctrines are not to be confused. The doctrine of exhaustion of administrative is invoked as a defense to judicial review of administrative action, not as yet thence the complete, if applied with the claim or matters as recognizable in the first instance by administrative agency along judicial interference until the administrative process has run its course. Question of primary jurisdiction. On the other hand, arise with both court and administrative agency have jurisdiction to pass and question with the particular cases presented to the court as original matters rather than the matters of review, and typically operate a suspension of the judicial process, finding suspension of judicial process administrative agency. Illustrative case. Racehorse owner did not move for the reconsideration of the change or cancellation of his horse certification of registration, not appeal to superior administrative agency, before the illustrating as the suite of the court from damages. Facts. Plaintiff, appellant, is the legitimate owner of the racehorse, which was duly and officially registered with the defendant's appellant, NSF, a certificate of registration, and legally authorized racing club of track. The standard operation process that day before the date of the race with application was approved by the Philippine Racing Club or INC. On the very day when racehorse was scheduled to participate in the race of November 15, the PRC INC announced through the public address system before the start of race number 13 that the horse was being included in the race number 15. It was the alleged that the withdrawal of cancellation of the certificate of registration of the racehorse. Ito pong pangyayaring ito is na-suspended po yung laban niya na dapat ay magaganap ito nung race 13 na natuloy po ng race ay 15. Issued, does have a valid cause for complaint held. Prematurely institute a set of the court for damage the reason for the shortening administrative processes is not explained by the applicant, then the order dismissal as the being derogational of the due process guaranteed. Process of function of primary jurisdiction was further lent and support the decision of appeal of that failure to apply, such as the basic concept of extension of administrative remedies would be extended with the consequence adverse to such a qualifier settled by the Constitute of Administrative Law of Primary Jurisdiction and Presentence of Review. Concept of primary jurisdiction disregarded by the resorts of judicial forum. The important things is the disputes determined according to judgment and the American Supreme Court decision, tribunal appointed by the law and enforced by the experience and Solicitor General of the Games and Amusement Board. Lately, qualification to view manifold aspect are applied to. Thanks po sa lahat.
At ngayon ay aking tatalakayin ang tungkol sa relation between exhaustion doctrine and due process concept. Although exhaustion of administrative remedies and due process are separated and distinct concepts, they embody linked and related principles. Number 1. The first applies when the ruling court or tribunal is not given the opportunity to re-examine its findings and conclusions because of an available opportunity that a party seeking source against the court or the tribunal's ruling omitted to take. Number 2. Under the concept of due process, on the other hand, a violation occurs and a court or tribunal rules against a party. Ngayon naman ay dadako tayo sa doctrine for judicial review. This doctrine, like that of exhaustion of administrative remedies, determines the point of what each court may review administrative action, except take the former applies to administrative action other than adjudication. Number 1, the basic principle is that the judicial machinery should be conserved from for problems which are real and present or imminent, and should not be squandered on problems which are future, imaginary, or remote, because problems for administrative action and problem of statutes for judicial review are often inseparable. The two are considered together by writers. Number 2, the background for the rule concerning the timing of attacks upon administrative regulation is found in case involving the constitutionality of statutes. Indeed, from the standpoints of timing challenges, regulations are hardly distinguishable from statutes. A possible difference is that the statutes are invalid only if unconstitutional, but that regulations are invalid only if they are either unconstitutional or in excess of state authority. B, another difference is that a statute have the force of law, but the regulations may be either legislative or interpretative, and interpretative regulation may sometimes lack the force of law. It should be noted that courts do not necessarily inquire into the validity of interpretive regulation, but they may simply make their own interpretations, giving such weight to such regulation as they seem to deserve on their merits.
Hi, I'm Sheine Basijan, 33 ABPS. My subject is Legal Aspect of Administration. Topic report is Expectation of the Doctrine of Exhaustion of Administrative Remedies. Number 1. An issue is normally rape of judicial determination when interests of the plaintiff are in fact subjected to the immediately threatened with substantial injury. Number 2. A situation may be rape of constitutional challenging in advance of official action if the situation is self-executing, that is, if the mere exiting of the situation of books without information in fact cause substantial injury to plaintiff. Number 3. A situation of regulation which is impracticable such criminal prosecution should be subjection to challenge in answer of injunction of declaration judgment bound by a party who immediately confronted with this problem of complaining of violating which of criminal penalty should not be extended as the price of challenge. Number 4. Debility legal uncertified by reason which is the private parties may be injured, curiously enough, should be justify is result to the judicial machine, machinery. When a owner of real property find that an uncertainty of his title may be advanced in effect as sales of property. Number 5. When the planning is in fact substantially harmed by the benequences of a situation, the benequences should not be demanded, and a group of reposing to determine whether that situation of void of benequence of to allow a declaratory action to the change of benequence situation unjustly process the challenging party into the dilemma of either disadvantage complaining of the risk penalty. Number 6. Information the administrative action may be deserving of judicial attention as the most formal order or regulation such a instruction issued by administrative agency should be held rep of review when no administrative remains is ability and the party effect of immediately contend with the choice between compliance and non-compliance, and violation of the instruction is criminal offense. Number 7. The government action is continued up until the plaintiff's action is upon the other event does not necessary that the government action is aspect of challenge. The test is still other substitution injury to the plaintiff's personal of immediate. Number 8. When substantial adverse effect upon the plaintiff from a situation or other government action is either present of the issue of legally should be normally be demand unray of judicial determined aspect the result of the court should recognize the judicial inspection to decide the issue to the legally in special circumstance.
Hello, my name is Carlo C. Colinayo from ABPS 33. Ripeness Doctrine and Primary Jurisdiction Doctrine distinguish. Number 1, both ripeness and exhaustion doctrine determine at what stage a party must secure judicial review at administrative action. The doctrine of primary jurisdiction determines whether the court of the agency should make the initial review. Yon. So, ang ibig sabihin nito ay kung anong stage maaring ma-secure ng isang partido ang pagsusuri sa kanila, and yung doctrine at primary jurisdiction determine kung dapat ay ang korte o ahensya ang dapat gumawa ng paunang decision. Okay, so number 2, question of ripeness and exhaustion may arise whenever judicial review of administrative and judicial jurisdiction are concurrent for the initial decision of some question. The function of primary jurisdiction is merely to determine which tribunal shall make the initial determination are not which shall make the final determination. The question is whether the court will refuse to act at all. So, ito nga. Ang question of ripeness and exhaustion ay maaaring lumabas tuwing ginagamit ang individual review of administrative action. Pero yung palaging talagang ginagamit is yung question of primary jurisdiction. Para matukoy kung aling tribunal ang dapat gumawa ng initial determination o paunang pagpapasya at kung alin ang dapat gumawa ng final determination. Ang tanong dito ay kung tatanggi ba ang korting isagawa ito. Yan. Okay, next tayo sa scope and extent of judicial review. Number 1, type of agency determination for purpose of judicial review. A. Determination of law which are fully removable. Okay, ibig sabihin nito, pagpapasya ng batas kung saan lahat ay isinusuri. Yan. B. Determination of acts review of which is limited to finding the extent of substantial evidence. Pagpapasya ng katotohanan kung saan limited lang sa paghaharap ng evidence o katibayan. So, number C, discretionary determination which are removable only to ascertain whether the action taken was arbitrary or capricious. Dictionary determination, dito naman ay susuriin lamang upang malaman kung ang kinikilos niya ay arbitrary o makatwiran. Number 2 na tayo. General frame of power. The general frame of power of judicial review is to keep the administrator within the valid statute which guides him and keep him from unreasonable excesses in the exercise of his function. Ito, tungkulin nitong panatilihin ang mga tagapangasiwa sa wastong pagsasagawa ng kanyang tungkulin para din matiyak kung mayroong utos sa batas at ang katibayan para sa nagawa ng ahensya administrative. Limitado lamang ang mga tanong sa korte na makakaapekto sa ating konstitusyon, authority na ayon sa batas at ang mga pangunahing patunay o evidence. So, number 3 na tayo. Okay, number 3 na tayo. Review is limited of fundamental feature or judicial review of administrative action is a limited review. A judicial review as extremely limited in regard to finding of fact and to accept judgment of an administrative agency acting within its statutory authority. The courts must not usurp to functions of the administrative agency, nor intrude upon the domain which the legislature has entrusted to the agency. So, ibig sabihin nito is limitado lamang ang paghaharap ng mga ebidensya. Ang korte ay hindi dapat agawin ang mga pumapasok na ipinagkatiwala ng mambabatas sa ahensya. Yan. So, B na tayo. The power of judicial review is not the power to determine whether the action of an administrative agency is right, correct, proper, advisable, expedient, or best fitted to the situation involved. So, ibig sabihin nito, the power of judicial review is not the power para matukoy kung ang ginagawa ng isang ahensya ng administrative ay tumawasto at pinaangkop sa sitwasyong kinasasangkutan. C. The relief is available for mere error or honest error by an administrative agency, particularly is a collateral proceeding. However, it is general rule that decisions of administrative agency are reviewable and reservable for mistake of law or an erroneous view of the law. Ibig sabihin nito, no relief is available for mere error by an administrative agency. Particular sa isang collateral, ito rin ay isang general rule na ang decision ng ahensya na administrative ay masusuri at mababago para sa pagkakamali ng batas. Yan. Okay, di na tayo. The court will not inquire into motives which impel action by the administrative agency, for that does not affect the legality or validity of the action except whether it involved fraud, malice, and internal wrongdoing. The court will not inquire into motive or motive na pumipilit sa aksyon ng administrative agency sapagkat hindi ito naapektuhan sa legalidad o bisa na ginagawa maliban kung masasangkot ito sa pandaraya, masamang hangarin o sadyang maling gawain. Yan. E na tayo. E. A court may require an administrative agency to comply with the law and its rule and regulation, particularly those prescribing notice and hearing, but it may not require it to decide a controversy in a particular way. Ang isang korte ay maaaring nangangailangan ng isang administrative agency na sumusunod sa batas at mga tuntunin at regulasyon nito, particularly na ang mga paunawa at ngunit maaaring hindi mangailangan ng pagpasya. So, ayan. Sa F naman, the determination of an administrative agency as the operation, implementation, and application of law which is entrusted to enforce is accorded great weight is a presume that an administrative determination is correct, legal, and just belief, and suspicious and conjecture cannot overcome the presumption of regularity and legality of official action. The burden of proof is on the party assailing the regulator of official proceeding. The determination of administrative agency ay tungkol sa pagpapatakbo, pagpapatupad at pagpalapat ng batas. Ito ay isang pagpapasya sa administrative kung tama o legal at makatarungan ang mga paniniwala. Hinala at haka-haka ay isang maaring mapagtagumpayan ng paglalagay ng legalidad ng mga opisyal na ginawa. So, ayun lang po. Maraming salamat. Thank you.
Good afternoon, ma'am. I'm Perlito A. Honorio Jr. and my topic report is Judicial Review or Relief Against Administrative Actions. Judicial reviews does not import trial de novo. It means that judicial review of executive or administrative decision does not import a trial de novo. Example, a review of the evidence all over again, but only an ascertainment of whether the administrative findings are not in violation of the Constitution or of the laws, and fraud or imposition, and whether they find reasonable support in evidence. Submeanings. Number 1. It is not for the reviewing court to weigh the conflicting evidence, determine the credibility of the witnesses, or otherwise substitute its own judgment for that of the administrative agency on the sufficiency of the evidence. Number 2. Common sense dictates evidence that the question whether the administrative agency abused its discretion in weighing the evidence should be resolved solely on the basis of the proof that the administrative authorities had before them and no other. Number 3. Administrative decision in matters within the executive or administrative jurisdiction can only be set aside on proof of gross abuse of discretion, fraud, or error of law. To assume that after administrative decision has been rendered, the courts are then free to retry the case de novo, is to misconceive the fundamental mission of judicial review. Number 4. There cannot be a trial de novo in administrative cases since a review of an administrative finding is limited to the evidence already presented before the administrative body. This rule bars the presentation of evidence aliunde and limits the court's function to determining whether the evidence in the administrative records substantial enough to support the findings therein. Methods or modes of relief or review. The methods of obtaining judicial from of review of action and administrative agency has been roughly classified as direct or collateral or indirect, statutory or non-statutory, including this latter method damage suits against the agency or its officials, and action for restitution. Statutory or non-statutory, including in his latter term any remedy not specifically made available by a statute relating to action of an administrative agency or agencies. The choice of remedy is a matter of importance, since one remedy may be more expeditious or less burdensome than another, and the scope of review may vary with the remedy. And that's all for my topic report, ma'am. Thank you po.
Hello, ma'am. Good day. I'm John Paul Romasanta of ABPS 33, and this is my report. Statutory methods of review. The statutory methods of judicial relief from or review of action of an administrative agency may be divided into three groups. Judicial relief is a legal remedy, also referred to as a judicial remedy. It means which a court law, usually in the exercise of civil law jurisdiction, enforces a right, imposes a penalty, or makes another court order to impose its will and in order to compensate for the harm of a wrongful act inflicted upon. Ayun po yung ibig sabihin ng judicial relief. Ang statutory methods of review is divided into 3 groups. Number 1 is where remedy itself governed by statute. Ibig sabihin nito is kung saan ang lunas mismo ay ang pinamamahalaan ng batas. Where remedy itself governed by statute. Ang ibig sabihin nito is statutory methods in the broad sense of the term are afforded where the remedy itself is governed by statutory provisions. Although the express terms of such statute relating to administrative agencies may make no provision that this remedy shall be available for the review of agency action. An illustration of this type of statutory methods is the declaratory judgment, which is purely a creation of statute. Ayan po yung number 1 ng statutory methods of review. Number 2, where proceedings in court required by statute for enforcement of administrative decisions. Kung saan ang paglilitis sa korte ay hinihingi ng batas para sa pagpapatupad ng desisyon ng administratiba. A statutory method of review is afforded where statute governing the action of a particular administrative agency does not permit the enforcing of an administrative decision except by proceedings in a court to be instituted by the prevailing party of the administrative agency itself. And these proceedings are designed for judicial review of the agency action. Ayun po yung number 2. Number 3, where direct judicial review afforded by legislation providing generally for such review. Sabi dito is kung saan direktang pagsusuri ng panghukuman na binigyan ng batas na nagbibigay ng pangkalahatan para sa naturang pagsusuri. Ito ay statutory methods of review in a narrower sense, sometimes called direct review proceedings, are afforded by legislation providing generally for review of action of administrative agency in prescribing the manner and extent of such review, whether by way of appeal, injunction, declaratory judgment, or simply by a provision for suit, action, civil action, or petition to a court of original jurisdiction, where the right of appeal is granted by statute. One who seeks to avail of it must comply with the statute or rule in effect when that right arose. Ayun po yung 3 groups ng statutory methods of review. Next report ko po is non-statutory methods of review. Ang non-statutory methods of review po is the fact that a statute does not provide for judicial review of action of an administrative agency, does not preclude the courts from providing such as is necessary or required. In the absence of statutory provision for review, relief may be had in appropriate case by means of the common law or prerogative writs such as certiorari, mandamus, habeas corpus, waranto, and prohibition. So, ayun po ang aking report, ang statutory methods of review at ang non-statutory methods of review. Thank you.
Good day. I'm Mirlito Castillo. I'm going to report about the continuation of relation between the two methods. So, number 1, where a statute relating to administrative agency provides a direct method of judicial review of agency action and is applicable, such method of review may be regarded as exclusive and to preclude the use of any other or statutory method. Number 2, some cases hold that statutory method of review is exclusive, but that it must be exhausted as a prerequisite judicial relief by some other methods. Number 3, in some instances, the existence of statutory review has not precluded a review by means other than as provided in the statute, especially as to act, which are entirely unwarranted on where exceptional circumstances is inadequate of the statutory remedy may provide as a basis for relief by some other methods. So here are the same illustrative cases. So the first case is the appeal. Appeal to the court was taken with reglementary period of 30 days counted not from the receipt of the decision but from the denial of the motion of the reconsideration of the decision of the administrative agencies. So the issue here is should the time during which the motion for reconsideration was pleading be deducted from the 30 days period for taking the decision to the court. So the ruling of the court, appeal to the court to be made as an ordinary civil actions. So the law significantly provides that the decision shall be taken to the court as in ordinary civil case. In other words, the appeal may be taken in some manner as appeal are made in the courts of justice in ordinary civil actions. And there is time during which motion has been pending to deducted from period for appeal. So the appeal may be taken by serving upon adverse party and filing with the trial court within 30 days from notice of an order or judgment, a notice of appeal, an appeal bond, and a record on appeal. Number 3, right to appeal from the decision. Statutory right. So the right to appeal from a decision of administrative agency is a statutory right. It can be invoked only in accordance with manner. And the second case is appeal. Petitioner invokes Supreme Court certiorari jurisdiction over the Commission on Election, not its affiliate jurisdiction. So the issue here is whether the petitioner should be granted or dismissed for lack of merit. So the ruling of the court is definite tendency to enhance and invigorate the role of COMELEC as independent constitutional body. Then the certiorari jurisdiction limited in scope and extent compared to a review. The legislative construction of the modified 14th constitutional provision is to the effect that the accusation of commission and final executory and even inappealable. And review and certiorari distinguish. A review includes digging into the merits and unearthing errors of judgment, while certiorari deals exclusively with grave abuse of discretion. So the third case is a certiorari form of petition against Court of Industrial relation is that the special civil action of certiorari, but appeal by certiorari eh, is intended. So the issue here is may the Supreme Court pass upon the question. So the ruling of the court is no. Appeal by certiorari is different from special civil action of certiorari. Case disposed of as appeal by certiorari. And the fourth case is certiorari. The Supreme Court passed upon not only legal issues involved but also the finding of facts upon which the decision of court of the tax of appeal is based. So the issue here made the Supreme Court considered the question of the facts involved the controversy. So the ruling of the court is yes, there are two ways of elevating a ruling of CTA to Supreme Court by fully ako of appeal and writ of certiorari in the proper case. Supreme Court may interchangeably consider petitioner for a review as petition for a writ of certiorari and vice versa. Collector of internal references filed notice of appeal. And the fifth case is mandamus petition as the Supreme Court to order the Secretary of Interior to confirm the final results of the physician's examinations. So the issue here is the official duty of the Secretary of the Interior is in nature. So the held is no. The ruling of the court is no. Secretary is a discretionary under the law. Mandamus not available to review exercise of discretionary by a public officer. Writ of mandamus is not issued to control or review the exercise of discretion of a public officer. Mandamus may issue to correct abuse of discretion. Mandamus may issue to correct abuse of discretion if the case is otherwise proper. And sixth cases is mandamus. Court granted petition asking it to order the Philippine Veterans Board to release treasury warrant and the preparation of which was made by mistake. So the issue here is was it proper for this lower court to compel the delivery of warrants. So the ruling of the court is no. Court improperly intervened in order to in ordering delivery. It is important to compel delivery of the warrants, and even its refusal should be wrongful or erroneous. And then the seventh case is prohibition. It is the petition asks the Supreme Court to prohibit the deportation from continuing deportation proceeding against petitioner who claims to be a Filipino citizen. And the issue here is should the question of alienage of citizenship be decided first in judicial proceedings pending the deportation proceedings in the meantime. So the ruling of the court is the jurisdiction of deportation board of dependent upon alienage of respondent in deportation proceeding. There is no question that as the power to deport is limited to aliens only. Respondent right to have his citizenship reviewed by the court after deportation proceedings. There is also no question that respondent who claim to be a citizen and not therefore subject the deportation has the right to have his citizenship reviewed by the courts. Judicial review not allowed in all cases and proper in case at bar. And the eighth case and for the last case is the prohibition. It is a petition asked the Supreme Court to prohibit the Secretary of Labor from reviewing license to recruit laborers or issuing any new license. So the issue here, does ground exist for issuance of writ of prohibition? So the ruling of the court is no. Function of writ of prohibition is to prevent the doing of an act which is about to be done. No grounds exist for issuance of writ. That's all. Thank you very much.
Injunction. Petition prays for the return to petitioner of his radio transmitter seized under a search warrant. Facts. Petitioner L is the holder of the franchise authorizing him to construct, install, maintain, and operate radio station in the Philippines. He filed an application for the renewal of the first license and paid the corresponding fees. L filed the second application for renewal and paid for the corresponding fees. Upon application of one of the respondents, supported by sworn statement subscribed by another respondent, the Court of First Instance issued a search warrant authorizing them to search radio station of L and to seize and take possession of the radio transmitter used threat allegedly in violation of law. Subsequently, L filed with the Supreme Court a special civil action of mandamus with the petition for the issuance of preliminary mandatory injunction against respondents. Issue: is there justification for the grant of the preliminary writ of mandatory injunction paid for? Held, yes. Number 1. Seizure amounted to closure of station and or non-renewal of license. The fact that petitioner have been allowed to operate this radio for so long, and because of the seizure of the radio transmitter, petitioner's station cannot continue broadcasting program. The seizure amounted to the closure of the station and or disapproval of petitioner's last application for the renewal of his license. Number 2. Requirement of hearing applies. While as already stated, petitioner's last application for renewal of license has not been disapproved, but also before the Radio Control Office may lawfully do anything that, for all practical purposes, this precisely is the situation obtaining in the present case. Number 3. Petitioner clearly entitled to issuance of preliminary injunction. Courts should exercise great care in granting preliminary mandatory injunctions. Court should not hesitate granting writ. Injunction. Petition for certiorari seeks to nullify resolution of Court of Tax Appeals restraining the collector of internal revenue from collecting taxes allegedly due from a taxpayer. Facts. The Court of Tax Appeals or CTA promulgated a resolution restraining the collector of internal revenue from collecting through summary administrative method taxes allegedly due from a taxpayer. The collector filed a petition for certiorari to nullify said resolution, contending that the respondent court acted in complete disregard of the prohibition of Section 305 of the National Internal Revenue Code when it restrained the former from executing the warrant of distraint and levy against the properties of respondent. Issue: may the collector of internal revenue be restrained from proceeding with collection, levy, distraint, and/or sale of any property of the taxpayer? Yes. Number 1. CTA empowered by law to grant injunction to restrain collection of internal revenue tax. There may be instances like the one at bar. Number 2 is filing a bond, not a prerequisite for issuance of declaratory relief. Complaint prays that plaintiff be declared a Filipino citizen and entitled to acquire lands of the public domain. AZ appellant seeks the declaratory judgment of relief, pleading that she applied for the purchase of parcel of land belonging to the public domain. The applicant, being that Chinese citizen, is not entitled to acquire lands of the public domain. Opposition to her application raises uncertainty or insecurities as to her citizenship, which is prejudicial to her interest. Bureau of Lands would likely deny her sales application. He prays that after due hearing, judgment be rendered, declaring her to be a Filipino citizen and such entitled to acquire lands of the public domain. She be possessed of all the rights and privileges accorded to Filipino citizen. May appellant citizenship be determined in the complaint for declaratory judgment or relief held? No. Number 1. Administrative requirements prescribed to acquire lands of the public domain. AZ is not interested under a deed, will, contract, or other written instrument, nor are her rights affected by a statute or ordinance. Her grievance against FA who object to her sales application for a parcel of land of the public domain has not brought her under and within the scope of Section 1 of Rule 66 of the Rule of Courts. Sales application filed with the Bureau of Land must go through the different stages as prescribed by law until the Director of Land renders his decisions. From a decision of Bureau of Land and appeal lies to the Secretary of Agriculture and Natural Resources. No court may compel the Director of Lands or the Secretary of Agriculture and Natural Resources on appeal to decide one way or another any sale application as that is vested exclusively in them. Number 2. Complaint for declaratory judgment or relief, not proper remedy for determination of citizenship. Citizenship cannot therefore be determined as a complaint for declaratory judgment or relief. If she is a Filipino citizen, as she claims, she should go ahead with administrative proceeding in the Bureau of Lands and submit the evidence to prove her citizenship. Appellants may resort to the court if she exercise of her right as citizen be prevented or denied to compel the officers who prevented of denied her the exercise of her rights as a Filipino citizen. To allow her to exercise such right is not the action brought herein. Consequently, the court below should have dismissed it. Number 3. Issued involved not one of jurisdiction but availability if remedy sought. The decision raised by the first Assistant Solicitor General is not one of jurisdiction and does not involve the jurisdiction of the court below. The latter has jurisdiction to hear the and determine all action and special proceeding because of its general jurisdiction. It is not jurisdiction of the court below that is involved, but the availability of the remedy sought on the basis of the averments in the complaint. Asadjar versus Ardales and Bureau of Lands, 97 Philippines, 105-1, 1995. Declaratory relief. Petition prays that the Court of First Instance of Manila declare if the Commissioner of Immigration has a right to limit period of stay in the Philippines of petitioner as immigrants, and if opinion of the Secretary of Justice on the same subject matter is valid and constitutional. Fact. Petitioner were admitted to the Philippines on pre-arranged employment under the Immigration of the Philippine Act 1940, known as Commonwealth Act No. 613, with the express condition that their stay shall be limited to 2 years. Upon proper request, the Secretary of Justice rendered an opinion number 314 series of 1952, holding in effect that the condition imposed for the admission of petitioner to this country whereby their stay shall be for not more than 2 years was valid. They say they shall be subject to deportation. Appellants contend that having been classified as non-quota immigrants under Commonwealth Act No. 613, they should have been admitted for permanent residence in this country. The imposition of the condition limiting their stay to not more than 2 years by the Commissioner of Immigration is in violation of law. Issue. Is the contention of appellants tenable? Held. No. Meaning of immigrant under Immigration Act. Term immigrant under its ordinary definition denotes one who comes for permanent residence. There is nothing in the law which should preclude the view that the term may also refer to an alien who comes to this country either to reside permanently or for a limited duration. The Act makes its own definition, which is that the term immigrant means any alien departing from the place outside the Philippines destined for the Philippines. Number 2. Commissioner empowered to limit duration of stay of immigrants in the country. The term immigrant as above interpreted, which includes aliens coming both for permanent or temporary purposes. It cannot be correctly pretended that the limitation imposed upon petitioner as regards their stay in the Philippines. On the contrary, the power of Commissioner of Immigration under Section 20 of Commonwealth Act No. 613 would appear to be broad enough to include the authority to impose such limitation. Habeas corpus. Alien who was ordered to be deported had been in detention in more than 2 years because the government had been unable to ship him abroad. Facts. Petitioner M is an alien of Russian descent who was brought to his country from Shanghai as a secret operative by the Japanese forces during the latter's regime in the Philippines. The deportation board found that having no travel documents, M entered the country illegally and consequently referred the matter to the immigration authorities. The petitioner was then under custody, he having been arrested on March 18, 1948. Over 2 years having elapsed since the decision aforesaid was promulgated, the government has not found ways and means of removing the petitioner out of the country, and none was in sight, although it should be said that in justice to deportation authorities, it was through no fault to theirs that no ship country would take the petitioner. Issue. Is M entitled to be released from custody? Held. Yes. Number 1. Foreign national entitled to protection equally with citizen. Aliens illegally staying in the Philippines have none right of asylum therein even if they are stateless, which the petitioner claims to be. The protection against deprivation of liberty without due process of law and express for crimes committed against the law of the land is not limited to Philippine citizens but extend to all residents, except enemy aliens regardless of nationality. Number 2. Petitioner's entry into the country not unlawful. Whether an alien who entered the country in violation of its immigration laws may be detained for as long as the government is unable to deport him is a point we need not decide. Moreover, by its constitution, Article 2, Section 3, the Philippines adopts the generally accepted principles of international law as part of the law of the nation. Number 3. Petitioner entitled to writ and release from the custody subject na condition. Habeas corpus. Respondent filed an action for declaratory judgment to test the legality of the detention by immigration authorities. Facts. The board recommended the exclusion and deportation of the respondent M, who was under definition as an alien who entered the country through false and misleading statements. The trial court issued the order of preliminary mandatory injunction to set M free. Board of Immigration Commissioners petitioned the Supreme Court of the writ certiorari to annul and set aside the writ issued by the trial court, claiming lack of jurisdiction and abuse of discretion amounting the excess of jurisdiction by said court. Issue. Was M entitled to the declaratory judgment he filed in the trial court? Held. No. Number 1. Proper remedy to test legality of detention is habeas corpus. The issuance preliminary mandatory injunction was an abuse of discretion and excess of jurisdiction, because the principal sought was clearly not available. It goes without saying that the action should be brought in Manila, where he was detained. Board of Immigration Commissioners versus Domingo, 8 SCRA 661. 19631.
Number 1. Generally, the questions presented to administrative agencies and thus those as to which the problems of judicial reviews arise are generally recognized to be of three kinds of or types. Number 1. Matter of law, 2. Matters of fact, and 3. Matters of discretion or supra. Letter A. As a general propositions, it may be stated that the courts cannot or will not disturb the actions of an administrative agencies which is within its jurisdictions or not beyond its power or authority, and which is not contrary to law or which has a reasonable basis and is not arbitrary or capricious or an abuse discretion. And as to the findings of facts, regardless of whether or not they are consistent with the preponderance of evidence, so long as there is some evidence upon to which the findings could be made. Letter B. The obvious purpose of the rule is to free administrative agencies from the compulsion of applying technical rules or evidence, so that mere admission of evidence which would be deemed incompetent in judicial proceedings which not invalidate an administrative order, but the assurance of desirable flexibility in administrative procedures does not go so far as to justify orders without a basis evidence having rational probative values. Number 2. Questions of law. There is a questions of law in a given case when the doubt or difference arise as to what the law is pertaining to a certain state of facts. The controversy concerns the A. Correct application of law or jurisprudence to a certain set of facts. For a question to be one of law, it must involve no examinations of the probative value of the evidence presented by the litigants or any of them, the truth and falsehood of facts being such as questions involving the validity or constitutionality of a rule or regulation issued by administrative agencies. It is for the courts, not for administrative agencies, to lay down the governing principle of law and to determine what action is within or without the law, or if the law has been properly applied by the agencies. Letter A. Matters involving questions of law relate to constitutional issues, jurisdictions, compliance with law and required procedures, statutory interpretations, actions which are arbitrary, unreasonable, or an abuse of discretion, or tainted with fraud, bad faith, or international wrongdoing, since such actions are not accordance with the law or in excess of authority, and so forth of findings of fact by adequate evidence. Thus, whether the subject matter is controversies falls within the exclusive jurisdictions of a quasi-judicial body is a questions of law. Letter B. In general, it is said to be the functions of the administrative agencies to determine the fact of controversies and apply the law to those facts. On the other hand, it is said to be the functions of the reviewing court to decide whether the correct rule of law was applied to the facts found and whether there was evidence before administrative tribunal to support the findings made. C. While administrative determination of questions of law is persuasive on courts and carries with it a strong presumption of correctness, nonetheless the interpretation and applications of law is the court's prerogative. D. Where there is no conflict in the evidence or the facts are undisputed, there is presented questions of law for the reviewing court. Number 3. Questions of fact. There is a questions of fact when a doubt or difference arise as the truth or falsity of alleged facts. A questions of fact is one which is to be determined by the special circumstances of each case in the exercise of judgment and not by any fixed rule of law. It is not for the reviewing court to weigh the conflicting evidence, determine the credibility of the witnesses, the existence and relevancy of a specific surrounding circumstances, or the probability of a suspicion, or otherwise substitute its own judgment for that of the administrative agency with respect to the sufficiency of the evidence. A question of fact is a general rule, the concern solely of an administrative body so long as there is a substantial evidence of record to sustain its actions, even if such evidence is not overwhelming or preponderant. Thus, factual findings of administrative agencies that are affirmed by the Court of Appeals are conclusive on the parties and not reviewable by the Supreme Court. These rules holds true only when established exceptions do not obtain. A consideration and decisions of questions of law may involve considerations of controverted facts to determine what the questions of law is, but the rule is that a questions of fact is conclusive and not subject to be reviewed by the courts. In the absence of showing that such decision was rendered in consequence of fraud, impositions, or mistakes, other than error of judgment in estimating the value or effect of evidence, regardless of whether or not it is consistent with the preponderance of the evidence, so long as there is some evidence upon which finding the questions could be made. Letter B. Conclusiveness of the findings of fact by an administrative agencies. Examples: dismissals of an employee because of alleged union activities is not affected by the fact that there was a wide difference of opinion among its members, or some of these members dissented. However, a conflict between the factual findings of an affiliate administrative tribunal and a quasi-judicial office, National Labor Relations Commissions, and labor arbiter will necessitate review of such findings and the records to determine which conclusions are more conformable to the evidentiary facts. Number 4. Mixed questions or jaw and fact. There is no clear dividing line between questions of law and questions of fact. The issues may be mixed questions of law and facts. A. An administrative findings on a mixed questions of fact and law is subject to judicial review, on which the court was substitute its judgment for that of the administrative agencies. B. Where there is a mixed questions of law and fact, and the court cannot separate the elements to see clearly what and where the mistakes of law is, such questions is treated as a questions of fact for purposes of review, and the courts will not ordinarily review the decisions of the administrative tribunal. C. Where, however, jurisdictional or constitutional facts are involved, the administrative findings are subject to judicial review. 5. Administrative discretion. In general, courts have no supervising power over the proceedings and actions of administrative bodies, and this is generally true with respect to acts involving the exercise of judgment or discretion, and as already mentioned, findings of fact, discretion is the power to make a choice among permissive action or policies. There is a well-recognized distinction between judicial review and administrative discretion and substitution of judicial discretion for the administrative discretions. A. A court ordinarily may not or will not review or disturb an administrative agency's discretion which is within the limits of the power and jurisdiction conferred in the absence of a clear showing that such discretion has been exercised arbitrarily or unreasonably or unlawfully or in bad faith, and more. In other words, questions of policy discretions are reviewed only for unreasonableness, departure from statutory standards, and or lack of evidentiary support, and questions of wisdom, property or expediency are for the agencies and not for the courts. B. The court will not substitute its discretion or judgment for that of the administrative agencies, which is treated with finality, but will determine the unlawfulness of these actions. The rulings of administrative agencies on questions of law, while as not conclusive as its findings of facts, is nevertheless persuasive and given much weight, especially if the agency is one of special competence or experience. C. A long line of cases establishes the basic rules that the court will not interfere in matters which are addressed to the sound discretion of government agencies entrusted with the regulations of activities coming under the special technical knowledge and training of such agencies. The exercise of administrative discretion is a policy decision and matter that can be best be discharged by the government agencies concerned and not by the court. Indeed, issues involving basically technical matters deserve.
On appeal, the Secretary of Agriculture, Natural Resources Incorporated, Portion B, with the Homestead of F, on the basis of motion for reconsideration by I, the Secretary rendered the second awarding the question portion BC to the F, subsequently upon motion for reconsideration by AB. The Secretary rendered a third decision declaring portion C as part of sales application of AB, and the decision concerning portion B has a final executory office of the President to the Assistant Executive Secretary on appeal by the heirs of MB and AB included both contest partition. In the homestead application of F, alleging that this decision was rendered with abuse discretion, has in access of jurisdiction, LB, the daughter of MB and AB, filed a petition for certiorari with the Court of First Instance for the review and annulment of said decision. The trial court dismissed the petition entera for filing allege any error committed by the respondent, executive secretary, and his finding of fact of conclusion which would constitute a grave abuse of discretion as required by Section 1, Rule 65 of Rule of Court. LBS interposed a appeal to Court Appeal, which filed the case the Supreme Court on the ground that only question of law are involved issue are the issue raised by the LB before Court of Appeal involved only question of law, assuming there has error committed by the executive certain did I constitute a grave abuse of discretion by consequently annulable by certain held. Yes, when question one of law or one of fact, the issue raised by LB in her appeal before the Court of Appeal do not call for examination of probative value of evidence. As a matter of fact, no evidence was represented before the trial court. The only issue is the correctness of the legal conclusion drawn by the construction made by the trial judge of the pleading of in LB petition before said court for question to be one of law. It must be involved an examination of probative value of evidence presented by the litigants. There is question of law when the doubt or difference opinion arises as to what is law on a certain state of fact. Upon the other hand, there is question of fact when the doubt difference arises has the truth falsify of the fact alleged. Number 2, error of judgment non-annulable by certiorari. As found by the trial court of allied, error of the respondent official is must merely an error judge not consulting grade of use of discretion and consequently not annulable by certiorari. Third, finding of fact by executive official general conclusive upon the court, it is well settled that the finding of fact that competent executive official are exclusive upon the court and not subject to judicial review in this absent of showing that the decision was rendered as result of fraud, imposition of mistake other than error judgment in estimating the value of the evidence. 4. When grave abuse discretion committed, in other words, decision of administrative officer should not be distributed except when they have act without in excess of their jurisdiction or with grave abuse of discretion. The abuse of discretion must be apparent and gross as amount to an evasion of positive duty or to habitual refusal to perform the duty enjoined on grave abuse of discretion and consequently not annulable by certiorari. Third, finding of fact by executive official general conclusive upon the court, it is well settled that the finding of fact that competent executive official are exclusive upon the court and not subject to judicial review in this absent of showing that the decision was rendered as result of fraud, imposition of mistake other than error judgment in estimating the value of the evidence. 4. When grave abuse discretion committed, in other words, decision of administrative officer should not be distributed except when they have act without in excess of their jurisdiction or with grave abuse of discretion. The abuse of discretion must be apparent and gross as amount to an evasion of positive duty or to habitual refusal to perform the duty enjoined or to act at the contemplation of law, as where the power is exercised in a arbitrary or desperate manner by reason of passion or personal hostility. Not every error in the proceeding of erroneous conclusion of law, fact, abuse of discretion. Ignacio versus Court of Appeal. Director of Plan rejected cell application for a tract of public land on his conclusion. From the fact, found that applicant was Chinese citizen. Fact, a petitioner appeal filed an application with the Bureau of Land for the franchise of a tract of public land following investigation conducted by the Bureau of Land. Our application was rejected, allowed him, however, to file a sale or release application for the portion of the land classified to able for commercial purpose. 2 motions for reconsideration of the decision were filed and denied on appeal to the Secretary Agriculture and Commerce. The decision was affirmed. One condition for the franchise purchase, one condition for the purchase of the tract for public agricultural land powered by the Public Land Law, Article number 2874, is the franchisor shall be citizen of lawful age. On his application still, but he was a Filipino citizen, but Director of Land found and held that one contrary or was Chinese citizen. It was conceded by the Director of Land by the presumptively of O was a Filipino citizen, but certain act of were pointed to demonstrating that he had forfeit his Philippine citizen. Thus, it was state on voluntary apply for landing certificate of residence, which is issued by the insular collector of custom, and which is only given the Chinese person also. When applied for the registration of a boat, and it was denied by the insular collector of custom on the grounds that the apply was Chinese citizen of submitted to the ruling of SIC that insurance of rape mandamus directed against the Secretary Agriculture and Commerce and the Director of Land for the purpose of compelling them give due course to his sale application for tract. The public land issue was the question of law. If should be considered a Filipino citizen, arising from the undisputed evidence correctly decided found by the Director of Land. Hailed. Decision of Director of Land when approved by the Secretary General conclusive. On court, the Director of Land performed his function pursuant to the provision of the Public Land Law. In coordination with this law, the Secretary of Agriculture and Commerce is made the executive officer charged with carrying out provision of the Public Land Law and to perform his duty to his Director of Land, Section 3, subject to the control of executive head to Director of Land, is by law vested with direct executive control other land matters, and his decision has to question of fact shall be conclusive when approved by the Secretary of Agriculture Commerce, Section 4. 2. The decision of the Director of Land, judicial officer entitled to great respect by the court. The foregoing analysis of the pertinent provision of the Public Land Law will show why is often in paragraph of the decision we accept the decision for the Director of Land on question of fact and conclusive. We would even go further and would hold that the Director of Land has been made by the law. Quasi-judicial officer has such officer has mixed finding of fact, even passes upon question of mixed fact and law, and consider and decide the qualification of application for the choice of public.
Hi, my name is Michelle Picache and I'm reporting grounds which would warrant reversal of administrative findings. As a general rule, factual findings of administrative agencies that are affirmed by the Court of Appeals are conclusive upon and not reviewable by the Supreme Court. They are recognized to this rule to wit. Number 1, the conclusion is a finding grounded of speculations, surmises, and conjectures. Number 2, the inferences made are manifestly mistaken, absurd, or impossible. Number 3, there is a grave abuse distraction. The judgment is based on misapprehension of facts, of findings, of facts or conflicting. The Court of Appeals overlooks certain facts of substance and value which the consider would affect the result of the case or justify a different conclusion. Moving forward for the judicial review of a relief against administrative actions. The agency in arriving at its finding went beyond the issues of the case and the same or contrary the admission of the parties of the evidence presented. The findings are conclusion without citation of specific evidence on which they are based. The findings of facts are premised on the supposed absence of evidence and contradicted by the evidence on record. The facts set forth in the petition as well as the petitioner's main and reply briefs are not disputed by the respondent. The agency has sustained irregular procedures and through the invocation of summary methods, including on appeal, has affirmed an order which tolerates violation of due process. The rights of a party were prejudiced because the administrative findings, conclusions, or decisions were in violation of constitutional provisions in excess of statutory authority or jurisdiction. Moving forward to substantial evidence rule. Substantial evidence rule, it means scintilla, such a relevant evidence as a reasonable mind might accept as adequate to support a conclusion. Substantial evidence rule has been defined as such relevant evidence as a reasonable mind might accept as adequate to support a conclusion even if other minds equally reasonable might conceivably opine counter or otherwise. Substantial evidence, quantum of a proof, administrative cases, substantial evidence is defined as such amount of relevant evidence which a reasonable mind might accept as adequate to support a conclusion. It is more than a mere scintilla of evidence. Last, the three types of hearing. Each party in an administrative case must prove his affirmative allegations with substantial evidence. The complainant has to prove the affirmative allegation in his complaint, and the respondent has to prove the affirmative allegation in his affirmative defenses and counterclaim. Next, in administrative cases, the courts cannot weigh once more the evidence submitted before the administrative body and make their own finding facts and substitute the same for the findings of facts the quasi-judicial agencies, because the court might be dismiss it. The last, he court generally only allows witnesses at trial. Trial, not the hearings. Hearings, the court relies on written declarations and your arguments. Hearings can determine a temporary, agreed, or some procedural matters. The trial is where you give evidence and arguments for the judge to use in making final decision. Thank you.
Justifiable decision or conclusion to the contrary not precluded. Substantial evidence. Described as such evidence as will establish a substantial basis of the fact from which the fact at issue can be reasonably inferred. Evidence need not be such as to preclude as justifiable decision. Two expert witnesses as to causal relation between disease and exposure, and the testimonies of such witnesses were diametrically opposed. Decision of the commissioner based upon the testimony of one such witness was held reasonably supported by substantial evidence. Court would reach the same conclusion on the facts as the administrative agency.
Jude B. Magsipoc, and I will be reporting test to be applied. Test to be applied is whether the evidence reasonably tends to support the administrative decision or findings, or whether the decision is not clearly contrary to the overwhelming weight of the evidence. It means that in the bigger case, in the criminal case, it needs to be have evidence to prove the decision of the administrative findings, and substantial evidence is more than a scintilla. Scintilla means is the small part of any kind of small part. For example, I'm sleeping and then I want to be my room is dark, then I will close the curtain, and then when I wake up, there's a small part of light. It's that called a scintilla, or small thing must do more than create a suspicion of the existence of the fact to be established as noted above. It is not necessarily preponderant proof as required in ordinary civil case, but such kind of relevant evidence which is reasonably might accept as adequate to justify or support a conclusion or decision, even if other minds equally reasonable might conceivably open otherwise. So, even if there's a civil case, if the evidence is said here like the preponderant proof as required in ordinary civil case, but such a kind of relevant evidence which is reasonable mind might accept is as adequate to justify your decision or your conclusion. And that's all. Thank you.
Good day, ma'am. My name is Ruben Cruz from ABPS 33, and my report is evidentiary values. Sinasabi dito na mas okay ang clear and convincing proof kesa sa preponderance. Kasi, preponderance means ito ay yung 50-50 lang na ebidensya. Hindi katulad ng clear and convincing is siya yung full talaga or mas malakas na ebidensya, panlaban. Yung illustrative cases naman is ito yung mga pag-aaral upang mabigyan ng kaalaman ang mga mambabasa sa karaniwang wika about or tungkol sa pinag-uusapan nila. Yung weight of administration naman is pagbibigay kahulugan ng pamahalaan ng administrasyon tulad ng ERB na tungkuling implement ng isang rebito. Ang trend fund naman ay isang natatanging kalakaran sa buong mundo tayo sa delegasyon ng ekonomiya sa maliwanag na nagdaang delegasyon. Pag umuunlad naman ang isang bansa is isa lang ang kahulugan niya. Ito ay nagpapatibay para sa hangarin ng isang bansa or isang ekonomiya. Yun lang po, and maraming salamat.
When rule not applicable. The substantial evidence rule has been held inapplicable in the following cases. First, where the statute provides for a trial de novo in which the rule shall not be invoked. Trial de novo means a new trial by a different tribunal. A trial de novo is usually ordered by an appellate court when the original trial failed to make a determination in a manner dictated by law. Second, where the statute has specified a standard of proof required to administrative determination, that is, the agency is required to make a finding by the preponderance of the evidence. Preponderance of the evidence, it means the jury will need to be convinced based on all of the evidence that there is greater than 50% chance that the defendant is guilty. Third, where the suit is not for review of the administrative order and is independent of the proceedings in which the administrative ruling under attack rendered. Fourth, where constitutional or jurisdictional facts are involved. And lastly, where property rights rather than privilege are involved. Here's are some illustrative cases. Number one, en banc order of Public Service Commission setting aside a decision of the division does not recite any circumstance to justify reversal. Facts. See petitioner appeal from an en banc split order by a 4-2 votes of the Public Service Commission, reversing an original decision of its first division granting C a certificate of public convenience to operate an ice plant in Cabuyao, Laguna. The en banc order denied C's application without questioning, much less setting aside the division's basic factual findings of public necessity or reciting any contrary fact or circumstance to justify reversal. Furthermore, the commissioner who passed the reversing order reversed himself, and the decision who passed the reversing order does not deny the facts proving the existence of the necessity of more ice supply in Cabuyao. Issue: must en banc order be set aside? Held: yes. First, Commission occupies by analogy the position of a interviewing court. It may be stated by analogy that the Commission en banc, when passing upon a motion for reconsideration of a decision rendered by entirely in the speculations, surmises, or conjectures, or are based on an inference that is manifestly mistaken, absurd or impossible, or are conflicting, or when the decision of the division is based on misapprehension of facts or mistake, or the findings of fact made are contrary to the admissions of the parties. No such exceptions apply here. Second, no contrary findings on fact made to justify reversal order. With all, the Commission and Bank does have the authority to review the evidence and record, and and when warranted, to modify or set aside the factual findings and conclusions of the decision rendered by the division. Since it is same commission with a full membership called upon to pass the rule upon motions for reconsideration of decision of its two divisions. But no such modification or contrary findings the fact were made by the Commission and Bank to justify in reversal of the decision of the first division. Third, such findings vital for sustaining reversal order. Stated in another way, it is vital for sustaining the majority reversal order that some mistake are appreciation for or such other notifying factors be shown in the decision's factual findings of public need and necessity, especially so where the then Commissioner Medina, without whose vote there would not be a majority to reverse, had fully concurred in the original decision, not yet has not established in the majority order of reversal the existence of any mistake or misapprehension of fact in the division's factual findings that would warrant its reversal. Second case, there is substantial evidence supporting administrative decisions that the stream in which dams were illegally constructed is not private property but a public navigable river. However, administrative investigation conducted was in violation of the requirements of due process. Facts: an administrative complaint was filed with the Office of the Respondent Secretary of Public Works and Commissions against a number of landowners, among them B. Petitioner, for abatement of appeal from the lower court's decision granting writs prayed for by B. Among the issues raised involves the courts finding that the stream which runs through the land of B is not a public navigable river but his private property. Issue: does the substantial evidence rule in administrative decision apply to the adjudication of claim of private ownership of property vis the government? Held: yes, where substantial evidence rule applicable, courts bound to look no farther. But there is a certain danger in leaving the adjudication of claim of private ownership of property vis-a-vis the government in the hands of an executive official. This danger is demonstrated by the very argument appellants under their third and fourth assignments of errors. They point to the evidence submitted at all administrative investigations and invoking the substantial evidence rule, assail the lower court's conclusions that the Matlaw stream is privately owned. The said rule indeed, which has been applied in a number of cases in the jurisdiction, is that if there is substantial evidence to support the finding of administrative official in matters within his competence, that is such relevant evidence as reasonable mind might accept as adequate to support a conclusion. The courts are bound to look no farther, not even to consider contrary evidence of a preponderance nature. Second, findings supported by substantial evidence not necessarily conclusive upon the courts. If the decision of the administrative official carries with it as the premises upon which it rests, a finding that certain property claimed by private party to be his while in fact is part of the public domain. It does not seem fair to take the finding as conclusive upon the courts, just because it's supported by substantial evidence, although there may be evidence to the contrary which, if properly considered and evaluated, would lead to a different conclusion. Third, investigations conducted with manifest disregard to requirements of due process. There is substantial evidence to support the conclusion of the respondent secretary that the Matlaw stream is a public navigable river. This evidence consists of the testimony and two witnesses, one a farmer and other a fisherman, and of the result of the ocular inspection conducted by the investigator, appellant Yunzon, as embodied in the report subsequently submitted by him and depicted in a sketch prepared by the assistant engineer of the Pampanga River Control Project. Nevertheless, we do not feel justified in affirming for purposes of adjudication the aforesaid conclusion of the respondent secretary and the reversing that of the trial courts for the investigation wherein the evidence received was conducted with manifest disregard to the requirements of due process. And it is solely on this ground that the members of this court agreed that this decision should be predicated. 4, investigation is set aside and issue of ownership left for determination in other proceedings. The judgment appeal from is affirmed insofar as it sets aside the administrative investigations is conducted by respondent's appellants, and the decision therein against petitioner's appearance, but none insofar.
Good evening, guys. My name is Lastomen Kent Joshua, and now I will discuss the judicial review of or relief against administrative actions. Liability of administrative agencies and officers. 1. Generally, The doctrine of judicial immunity from suit extends generally to government officials in respect to their acts of discretionary or quasi-judicial nature. The rule of immunity protects an officer from liability for a mistake or an erroneous construction and application of the law, of the facts including the officer's duties under the law. Number 2. Basis of the rule. The rule is simply one public policy designed to aid in the effective functioning of government and represents a balance between evils inevitable and either alternatives. Number 3. Exception to the rule. The suitability of government official depends on whether the official concerned was acting within his official or jurisdictional capacity, and whether the acts done in the performance of official functions will result in a charge of financial liability against the government. Letter A. A public officer enjoys only qualified, not absolute immunity, where the circumstances of the case are such as to render the officer personally liable. He is not licensed, he is not relieved from responsibility by a reason of mistakes and honest intention. Number 1. A judgment of discretion of a quasi-judicial officer, although exercised honestly and in good faith, will not protect him where his erroneous action, taken without hearing, result in positive injury to a private person for which there is no other redress than by action against the officer. Number 2. An officer is liable for his errors or mistakes. Number 3. Dishonesty, bad faith, malice, or corrupt motives will render an officer civilly liable in an action for damages for his erroneous or mistaken determination. Letter B. The state or government may be used only with its consent. A suit is against the state when a judgment therein would impose a financial liability or obligation on the government. Number 4. Official immunity and state immunity distinguish the doctrine of state immunity from suit applies to complaints filed against public officials for acts done in the performance of their duties. And lastly, the immunity of public officials is a make-limited principle. The governmental immunity, since its purpose is not directly to protect the sovereign, but rather to do so only collaterally by protecting the public official in the performance of his government function. That's all, guys. Thank you.